to do that. Good afternoon. We're a couple of minutes away from our 1 o'clock scheduled live broadcast with attorneys Robert Eckard, who practices federal and state law. And congratulations, because he just gained admittance into the Texas bar. How many bars is that now? This man is like nonstop, does not stop. Globe trotting constantly. Is it at one point is in Colombia, another country. So he's nonstop. And welcome, Robert. He's a good friend, great attorney, great human being, and he's going to do some legal analysis with another good friend of mine, attorney John McGuire. Thank you also for joining us today. Both of you, you're gonna both lead the bus today, because yesterday I did a back-to-back broadcast. This one is my last one until 2021. I'm exhausted, so you guys are gonna lead the bus on the discussion with the facts and the law. We're gonna talk about and as I'm doing this intro and hoping that people start joining in right before we start the discussion, that you are able to share from my page or the Florida You Judge page. You can share the link, the live stream. It's on there now, and just share it to your page so that your followers can follow the discussion. Let me know. I think my clock is 1 minute ahead. What time do you have, John?
Awesome.
We have 1 o'clock.
1 o'clock.
Okay, Haiti Oropesa with Florida You Judge. Thanks for tuning in. For those of you that have jumped on, good afternoon. And recently, at the beginning of the month, we all saw the headlines. It made national headlines, not only here in the state, but Rebekah Jones is a former employee of the state who built the COVID dashboard in the state. And at one point, she began a little feud with our Governor DeSantis, saying that she was being told to fudge the numbers on the COVID to make the state look good, as far as the numbers of infections and whatnot. And so after that clash, she's fired. DeSantis says, no, that's not the case. It's not about that. It's you're being insubordinate. She's fired. She goes and creates an independent dashboard. She's also getting leaks information to her phone or whatever device, giving her information from persons that are employed currently with the state. So this a couple of weeks ago, we learned through the news that she was her home was raided. FDLE got tipped off by the Department of Health, which she worked for, that she had gained unauthorized access or had hacked into the email system. There's questions about whether that system is actually a listserv that's available to the public or not, or that you need a specific password to gain entrance. But she's denied that. She's lawyered up. A lot of the public is supporting her. In fact, and I want my two guests and friends to comment on this, but we had let me share this real quick, because this is pretty powerful. Let me see here. Here we go. The GOP lawyer appointed by Florida governor resigns state panel in protest over raid on ousted data scientist home. That's huge. We have a GOP who's the same party as the governor, who's appointed to a very coveted seat of a judicial nominating committee. This is a committee that selects when there's an appointment that needs to be made in that specific circuit that he was selected for, the 12th Circuit. He's able to, along with other committee members, decide what names to go up to the governor for consideration for appointment to that circuit for any judgeships. So the Washington Post says in its headline, after the raid and the execution of the search warrant, which most of the country has seen, says a Republican lawyer resigned Tuesday from a Florida judicial panel to object to police raiding the home of a data scientist who has alleged the state health department ousted her for resisting unethical pandemic-related requests. Ron Filipkowski, who served on a nominating commission for the state's 12th Circuit, wrote an appointed resignation letter to Governor Ron DeSantis' general counsel, that he considered the search warrant executed on Rebekah Jones's home unconscionable. He also said it was indicative of the state's reckless and irresponsible handling of the coronavirus pandemic. It just seems like it's not really about any kind of criminal investigation, Filipkowski told the Washington Post. It's about intimidation of her and sending a message to the people currently working in a state government that this could be you. The state's public-facing portal of pandemic data has been under scrutiny since earlier this year when Jones, a former data scientist at the Florida Department of Health, was fired and began trading public accusations with the agency. She alleged that she was asked to undercount infections and overcount the number of people tested, while state officials said she had been repeatedly insubordinate. Okay, so who wants to start? Robert, you or John? I know both of you are anxious to jump in and weigh in. And we are having call-ins throughout the discussion. 813-221-9700 is the call-in line. Robert, who wants to go first?
John, I'll defer to you if you want to jump in there.
Yeah. Okay. So, Haiti and Rob, good to see you. There's two issues really. One is the warrant, the application for the warrant, and two is the execution of the warrant. So I reviewed the warrant, and it has all the relevant information of the location of the house, the description of the house, everything to be searched. But it failed to include the fact that Rebekah Jones was in a current lawsuit with the same branch that was applying for the warrant, that she was a fired employee, that she would have attorney-client privilege information on her computer, that she would have information that's protected by the Constitution under privileges for attorney-client privilege, freedom of the press. She qualifies as press when she's releasing this information. And that what that did was mislead the judge. So as attorneys, we don't criticize judges. If you don't like what a judge does, you appeal it, and you appeal it all the way to the U.S. Supreme Court. But in this situation, they intentionally left that out. They knew it, and they intentionally left it out. And that is improper conduct. And I think the affiant, who would have been present at the execution of the warrant, clearly showed his bias and I would say a corrupt nature in the application of this warrant. The second part of the problem is the execution of the warrant. And so what happens is once the FDLE officers got the warrant, they would have a briefing and a threat assessment. They would have seen there was a woman, her husband, and two children living in the home. They would know if there was any weapons or concealed weapon permits. They would do a threat assessment. Clearly, there's no threat here. This information that was obtained in the warrant is even questionable, even whether or not it's a crime. There's no sex trafficking ring or child pornography. And so clearly they didn't get a warrant that enabled them to kick the door in. So once they got there and she answered the door, she was smart enough to put her camera on and videotape this. It doesn't appear that these officers wore body-worn cameras, BWCs, which would have captured all the information. So they, in essence, were going free, thinking they could do whatever they wanted. They tell her to come outside. They start screaming at her, start screaming for the husband to come up downstairs, the children to come downstairs. They point a weapon. They unholster the weapon and point it upstairs where the children were and the husband. And I can tell you from my own experience, only one time have I had to pull a weapon when I had to clear a bank in the military. And I had my 45 out in one hand, a flashlight in the other. And I was scared to death. And if somebody had moved, I would have killed them. And somebody could have moved in this house and they could have killed them. The worst threat imaginable to a parent is someone pointing a gun at your children. This was done clearly to intimidate, to harass, and to scare other whistleblowers. And it's completely uncalled for and should not be tolerated in our country. We know that during Katrina, when General Henry rolled out in 2005 in New Orleans, the first thing he said is, put your goddamn guns down. These are American citizens. There was no reason they should have pulled those out. There was no threat in trying to get her computer that simply asked current employees to come forward and tell the truth. And for that, they had guns pointed at their children. And so that's my initial comments on it. And I'm interested to see how, Rob, you feel about it.
Listen, and for those of you who are viewing and will view after we finish this broadcast, John McGuire, prior to beginning his career as a criminal defense attorney, he practices in other areas, but he did have a career in law enforcement and was a prior law enforcement officer. I just want to, before Robert weighs in and begins his analysis, John, the first point that you made, you're saying that prior or when they gave the affidavit to the judge to review in order to gain issuance of a search warrant, you're saying that they failed to mention that there was a pending whistleblower lawsuit?
I didn't see that anywhere in the warrant. I've reviewed it 3 times. They should have disclosed all of the information, all relevant information. So if you could imagine you're the judge and you look at this application, you see what appears to be access to some communication system with the state. It's questionable whether that's even a crime, because if a police officer has a company issued cell phone, which is unlisted, and I call them on it and say, hey, there's criminal activity going on within the department, you should step forward. I can't imagine how that's a crime, number one. Number two, the bias that they had because they were being sued by Miss Jones, Rebekah Jones, should have been disclosed to the judge. If the judge knew that she had a lawyer, she was in litigation, that obviously all her attorney-client privilege is on that computer, all of her access to her sources of information for her reproducing this news, continuing to be a whistleblower, encouraging other whistleblowers to tell the truth, a judge would have looked at that much, much differently, and I'm sure would have said, well, what exactly is the crime? Is the crime trying to get more people to step forward and report crimes being conducted within the state of Florida, which is abuse of authority? It's a crime to fudge these numbers, these COVID numbers. You can't lie to the public. You can't use your position and then make up whatever numbers you want. You have to give accurate information. And so I think a judge would have had a much different approach if that warrant had included that information. I've never heard of a judge saying, geez, I got too much information, but they have to include all of it. There is no way from reading that warrant that that judge would have known that Rebekah Jones is engaged in litigation with the state of Florida, has a lawyer, was, in her opinion, illegally fired, and that currently was producing information and news about real COVID numbers within the state of Florida. So that should have been included, and it was not.
And some people are considering her to be a hero. And she has said that she's still going to fight on and speak truth to power, regardless of what has happened, what will happen. So some view her as being a hero. Robert.
I don't know how you could not view her in that way. She simply stepped up, told the truth, number one. Number two, she was smart enough to have a camera to witness this improper intimidation and sort of Gestapo tactics on her husband, her children. And I commend her for having that courage. And regardless of what political spectrum you're on, the Republican lawyer from Ron Filipkowski, who just resigned, this is his party, right? It's his party that's trying to say that COVIDs aren't that bad. And he resigned. He can't tolerate it. And I consider him a hero as well.
I do too. And you know what? I feel sad because at the end of one of the articles that came out, he says that he feels bad because I think the Republican Party chair, I think if I'm not mistaken, somebody up there in the party, the Republican Party, is the one that spoke to DeSantis to get him that appointment that he got accepted. And then now he's pretty much renounced it because of what we're talking about. The one thing that's very troubling that the public, the citizenry, the residents on DeSantis's watch, and I don't care. I voted for DeSantis the first time, and I am a regular now critic of DeSantis. Today we have a headline in conjunction to this. We have a headline today that says, this is the Tampa Bay Times today. DeSantis says Florida shipments of vaccines are on hold. Pfizer disagrees. So we have the manufacturer disagreeing with our governor as to the rollout of the vaccines, which this week he was out in Tampa Bay General Hospital touting, look. But now there's only a small percentage of vaccines, or not enough. Pfizer's their position is you all can be having more vaccines. All right. Though before giving it to Robert, John, I'm troubled by the fact that this person, like you indicated, she has attorney-client privilege, and that she's probably has communications that are privileged. The government should not be privy to. Now, if there are any such communications in her phone, boom, she loses that. Not only that, but reporters, listen, the freedom of the press, they are granted a privilege too with their anonymous sources. So if she has people that are as in her publishing role, because that's what she is, she's a publisher. Now she's developed an independent dashboard to give the people what she says are the true numbers. This is of incredible importance. We're talking about public safety. People are dying. One of our colleagues locally just published on Facebook, John Trevina, very well known. He just got COVID. So does his fiance, says that they experienced severe symptoms. So this is something that's very important. She's saying, I've got the true numbers. And DeSantis or the Department of Health, when she worked, they were trying to get her to manipulate it for political reasons, for policy reasons that DeSantis wants to implement based on how he wants to manage the COVID crisis. Robert, go.
All right. Well, I'm not here to debate the political overtones of this case, although it appears there are significant political overtones. As John has highlighted. Certainly you hope this is not a political prosecution, but to the extent there seems to be a pretty close nexus to those matters which are outlined in the affidavit for search warrant, the pending litigation, and the circumstances under which Rebekah Jones was terminated. There certainly seems to be a political motive here. But I'm not sure if that really matters, Haiti. Political motives sometimes help flush out things that are done that shouldn't have been done illegally. And we've seen that both at the state level and at the national level. And of course, whether it's politically motivated or not, if a crime's been committed, law enforcement has a duty to investigate it. Now, do they prosecute matters, or do they investigate matters that are more politically charged? It would appear to seem so. Getting to the warrant itself, this is not a simple analysis. We try to break it down under a Fourth Amendment search and seizure outlined for purposes of looking at the constitutionality of the validity of the warrant. And of course, you always start with the premise of analyzing the Fourth Amendment. And as everybody on the panel knows, if in fact we do have a Fourth Amendment violation, or the warrant is somehow tainted, then we all know the term fruit from the poisonous tree may allow for a judge to suppress any inculpatory evidence that's found for purposes of this case. I don't think the case is over. So certainly it's something that the prosecutor has to learn more about in terms of how the evidence was collected, how the information that the affiant in the affidavit received it, analyzed it, interpreted it, and then memorialized it to a judge in order to convince a judge that this warrant contained probable cause that a crime was being committed. And the crime, as you all know from the affidavit, is a crime under Chapter 815.06, which is the Florida statute that provides whoever willfully, knowingly, and without authorization accesses or causes to be accessed any computer system or computer network commits an offense against the computer users. So I think if you look at the statute, I think when we read that, it's patently obvious what is not in there. And what is not in there is intangible evidence. So the plain language of the statutory definition defines computer systems, and computer network, not the data and other information located on the device. I think that's an important distinction. So in order for the government, for the state to prove a violation of Chapter 815, they must establish that the defendant accessed one of the listed tangible devices without authorization, not that the defendant accessed a program or information stored on the device without authorization. And that's supported by case law. So we may be dancing on the tip of a needle, so to speak, in terms of distinction, but we can't ignore that fact. And I think when you have to do the analysis, that consideration has to be given. Now, let me just provide for our listeners 6 cybersecurity maxims. Number 1, nothing you do on the internet is secure. 2, if it is free on the internet, then you are a product. Number 3, in security arena, technology is a license to quit thinking critically. Number 4, most organizations hate security more than malicious adversaries. Number 5, most people assume adequate security is in place until they see proof it doesn't exist. The exact opposite of a reasonable approach. And number 6, the confidence that people have in security is inversely proportional to how much they understand it. And this is from a forensic security and investigative course. Those are the 6 maxims. So diving into this case, and let me play devil's advocate for a moment. And John, you're a police officer, so maybe your perspective is very important. But I'm just wondering how important, if at all, it would have been for a neutral and detached magistrate judge to know that there was pending litigation between Rebekah Jones and the government, the governor's office, or the agency in which she worked for. How important is that for a judge to know that information?
So the answer is, in applying for a warrant as a law enforcement officer, you must include all information, inculpatory, exculpatory, show bias. And if you, and Rob, we're both more familiar with drug cases. If the informant has been convicted of a crime of fraud or dishonesty, usually they can't include that informant in that. If the informant has a bias. So the fact that she was a journalist, number 1, just like if they're trying to get a warrant against the Washington Post, that's very important. And the judge, I can't imagine any judge would execute this warrant against a news agency, which she was, number 1. Number 2, the fact that she was litigating with the very branch of government that was seeking the warrant. They're 2 adversaries. Well, that would raise a red flag to a judge and say, wait a minute, what is actually the crime? I think if it was child pornography, it'd be different, right? But it's just simply her trying to get more whistleblowers. If she did it, a judge would say that's not enough to go search her house, to harass her children, intimidate other witnesses. And that bias would have led the judge to question more. We don't know what a judge would have determined, but in my mind, there's no way a judge would have executed this warrant knowing that there's attorney-client privilege on the computer, because all 3 of us know we communicate with our clients through our computers, emails. She has notes, she keeps records. That's number 1. Number 2, if she's getting information, there's more whistleblowers and informants that are turning in criminal activity, they've now been exposed and they can be intimidated. They can have their children have guns pointed at their faces. And so that, from a judge's perspective, would say, well, maybe I don't want to do that. Now that the government, the one she's suing, has the computer, they're going to find out where she's getting her sources from, which would have been friends of hers or coworkers. She's already said she has all their cell phone numbers. She knows all them. And trust me, I've sued government agencies and they all stick together. People who are current employees still talk to ex-employees because they were all on the same team at some point. So I think a judge needs to know all the information. And as a police officer, we're trained to give the judge all of the information. And like I said, a judge has never said, oh, this is too much information. The judge can make a decision once they see everything. This judge had no idea who she was, I guarantee it. No way he could have put it together. And
well,
I don't.
Let me ask you this. Does it really matter? And again, playing devil's advocate, and I used to be an assistant state attorney and a prosecutor. So I guess my thought goes to whether the end product of what was ultimately accessed, or the data or the message. You brought up child pornography. In this case, it was the dissemination of a message about COVID. Does it really matter what it is that, or drugs? Does it really matter? And I guess what I'm getting to is the statute talks about unauthorized access to gain this information, presumably. It doesn't talk about the type of evidence that's received or the type of evidence that's seized as a result of this. It just simply talks about the unauthorized access under 815. It doesn't give a laundry list of things that say, hey, here's the things that under 815 we're looking for. It just simply, because it can't possibly give an exhaustive list. It just identifies the unlawful access. So it's almost like a strict liability crime if in fact they can prove this unauthorized access. So I'm just wondering.
I know, Robert, but let me ask you this. Even though you don't want to get into the political motivation nuances that possibly may exist, possibly not, that's speculation. We don't know. But listen, don't you think if you were the judge, you would want to know that the person that's petitioning, requesting that you review to issue the rule in favor of, yes, I'm going to grant this and sign off on, wouldn't you want to know and be fully advised of the fact that there is a pending whistleblower lawsuit against the agency now that is seeking to go in and get this information that now you can't reverse it? The egg has been fried. The bell has been rung. Those privileged conversations, they've gained access to it. Now people, like John said, their lives they're under stress now and need to be worried. And her leaks, the tips that she's gotten that were to remain off the record, protected, are no longer. And her attorney-client conversations. What about that? Don't you want to be apprised of that if you're the judge, to kind of look really critically into whether you're going through the statute, whether there is probable cause for what they're asserting? I just spoke to attorney Craig Wisenhunt, who graciously has agreed we're going to coordinate at the beginning of the year for him to come on to talk about the IT issues, the network security issues, digital forensic cybersecurity issues, because she's saying, I didn't do this. There could possibly be someone who hacked into her system and then gained unauthorized access. He's going to verify some information that he has, that possibly that account that they're saying was entered into through unauthorized use may be something that is available to the public to communicate through. I don't know that. I don't want to certainly assert that, but that's an issue also through spoofing. He says it could either of those means. Spoofing is a term that's used. It's a process that whereby somebody hides their IP identity and assigns it to someone else. It's not the true IP through which the access was had, or actually hack into her system to then gain quote unquote unauthorized access, and then the blame will be directed at her. Wouldn't you want that information, Your Honor? And I say that facetiously in posing this hypothetical to you. Wouldn't you want to know the extra information that John is saying they should have maybe included?
Well, you've asked me quite a few questions, so I'm going to try to answer the simple one, because that's what I'm good at.
No, you're not. Your brain power there.
I would want to know. I would want to know, certainly as a judge, maybe the underlying motivation or involved in this obtaining this warrant. But I think more importantly, I'd want to know, and we've read this 8-page affidavit, and it seems to me, and no disrespect to the officer, but I'll guarantee if you read any more of his affidavits, a lot of these paragraphs are probably cut and paste, because a lot of it deals with his training and experience. I mean, there's probably 3 or 4 pages of just his training and experience, which is supporting why he has the knowledge to believe that probable cause exists. But if I'm a judge, I think I'm focusing on the second paragraph in page 4 of that affidavit, which talks about, through the use of his investigative resources, your affiant determined that the IP6 address, and lays out that address, resolved to Comcast subscriber Rebekah Jones. That is essentially the essence, right, of where he's getting his PC from.
Okay, let me stop you there, because that's a great point. That's a great point.
Let me finish my thought.
And I want to get back to that, though.
My other thought that John brought up, which is a very real issue, and you brought it up, it was a real issue for attorneys when our clients' offices or computers are searched and seized. It's happened to me. Generally speaking, and John, you can weigh in, but generally speaking, most prosecutors or law enforcement officers, through the use of prosecutors, will employ a taint team to come in and see if there's any data, attorney-client communications, privileged communications that should not have been retrieved, nor should they be read. So they try to segregate that off to a taint team, so that it's not read or it's not used. Does it happen? Does it somehow bleed over? Probably does. But of course, they're not supposed to be able to use those communications, nor will they be able to use those communications, because those are statutorily protected and common law protected under the 5th Amendment. So in terms of attorney-client communications, I've had it happen, and I've been contacted by the law enforcement agency or the prosecutor, and they've said they've employed a taint team, and they are not going to review those communications. But for purposes of communications that may be not protected by attorney-client, maybe they are just simply confidential communications between the reporter and their sources, or in drug cases between a defendant and other sources. This is certainly a major concern that we all should be concerned about. So if I'm a judge, I think I really, really want to focus in more on that paragraph. And it's incumbent upon judges to understand what cybersecurity, computer forensics, what it entails. And I mean, the transmission control protocol, the internet protocol, if you understand these concepts and how they work, there's a way to understand how what's called a sniffer program to secretly capture datagrams moving across the network and disclose that information in the data network protocol. So there's even, although the affiant didn't discuss these nuances, maybe he thought he'd confuse the judge. I think it gives us, the public, and the judiciary a deeper level of understanding and knowledge that this so-called onion was peeled back farther than just simply looking at where the IP address was connected to.
Okay, so let me ask you then, Robert. Are you saying, to maybe reiterate what you're saying, is that if there, because you're pointing to page 4 of the search warrant, and I'm gonna go ahead and share the blog that that search warrant is going to be published on tomorrow. I give you my word. For those of you who are watching, FloridaUJudge.com. Tomorrow I will, in its entirety, publish the Rebekah Jones search warrant for your review. But I want to ask you, Robert, since you made that point and focused in on page 4 of the search warrant, they're saying our investigation led us to this IP address. The subscriber of this IP comes back to Rebekah Jones. Therefore, we have probable cause to go in there and retrieve her devices. They in particular said this phone, this computer. But as you said, Robert, it's crucial for all of us in the system to familiarize ourselves. Thank God that I managed to today was able to speak to Craig, and he is the local guru of IT and cyber security, internet security. He's going to come on next week, and I'll ask him, and we'll have that discussion. The public can call in and ask him questions as to how we all better secure our private information, not only for us, for those of us who are attorneys, that of our clients, and for those who are in the journalism profession to protect their sources that wish to remain anonymous. Don't you think that maybe if you're the judge, again, hypothetical, looking at this, and then you're as a judge saying, you know what, yeah, I'm inclined to grant this affidavit, to grant the search warrant, if you knew that through spoofing, or if somebody has the technological know-how to hack into her specific computer, or through a spoofing mechanism to divert the IP to her, do you think you would be uncertain about whether to grant that search warrant or not?
I would.
Okay, there. That's the problem here. That is the problem here. Is this enough PC simply by saying this is her IP, therefore give me the search warrant and let's go in there? Because when you weigh what remedy does she have? You can send in a taint team. That's fine. But the government, once they look at, the very agency that's being sued by her is going to be able to see who her confidential informants are, those who are feeding her information that's critical, important to public release. They're now going to be on the radar of the government. That's not something they're going to scrub from their brain. They may taint it and not use it. Look how strongly you can speak to this, because you were a former prosecutor. John, you're a former law enforcement. The government takes great pains to protect their confidential informants, who they use as snitches against fellow citizens. So
let me just address one thing. The taint team is garbage. Judges know they're garbage. Once this information is in the hands of the executive branch, all the informants are going to be fired because they'll find them from her computer. Has nothing to do with the crime. This case has nothing to do with the crime. There was no arrest affidavit. Otherwise, they would have got an arrest warrant. It was just a search expedition for political purposes. There's no other way to look at it. A judge was deceived. And that's what is really important. There's no question that the judge was deceived. When you look at the 8-page warrant, they had pictures of her house. They described the shingles on her roof. The same affiant that applied for the warrant was at her front door. So they have to be, right, throughout the whole case. And, when that happens, the three of us know there was a case recently where Judge Burgess found that he was misled in a child pornography case in a warrant, and he threw the entire case out. Had nothing to do with whether or not the person possessed child pornography. But judges should not be misled. And had a judge been fully informed, the judge may have signed the warrant. The judge might have also said, you can take the computers, but I want you to hold them and no one gets a look at them until the defense lawyers are involved so that we know there's no dirty business going on. A judge could have made all kinds of safeguards, but the judge was denied that opportunity and was intentionally misled because it was held out. I don't know if this is a crime. I don't even think it is a crime. There's a difference again in what message was conveyed. And had the judge been told all of the information, the judge may have determined this is never going to be considered a crime that's prosecuted under any reasonable prosecutor's standard. And we know they must have a good faith basis to believe they can convict somebody before they arrest them. I think it was just a fishing expedition, and we all have rights to public information. And all she did was, if she did it, which she denied, was ask for people to step forward and admit the truth. That's all that was asked for in that sentence. And you can't really discern that from the warrant that was applied. And that's what I think the important thing is. Rob, you know that when people apply for warrants, law enforcement officers, almost never are they questioned. Judges sign them all the time. You go and you apply. They might say change a few words, but they're almost always granted. And most are never even challenged. I mean, I can only think of one in the last 10 years that was granted. And you know, I have one pending now, a challenge to a warrant. So they're pretty routine and pretty easy to get. But when a judge is misled, it's going to change everything. And I think that that's the real problem. The bell has been rung. You can't undo it. They have her computer with all this information. To think that the tank team, these guys are pointing guns at children, are not going to share the information with the governor's office, tell them who the informants are, and potential new whistleblowers, which would be people that are still contacting her, who her friends are. They're all about to be fired. The chilling effect of these employees that now they're thinking, oh my God, I've got a pension. I'm going to lose my pension. I'm going to lose my job because I was still talking to this ex-employee. I mean, it's just all those things were denied the judge and completely inappropriate. And that's how I feel. As far as the taint team, the judge, if he knew this, would have developed a system to protect it, because judges don't really buy the taint team. They would say, I don't want anyone touching this attorney-client privilege information until the attorneys have a chance to discuss it and work out a safe system. Then
John, we don't know at what time of day this warrant was presented to a judge, and certainly it could have been at 10 o'clock at night. And I tend to agree with you in terms of when they review these warrants for purposes of endorsing them, they're routinely endorsed. And I'm not suggesting that this one wasn't. What I do want to elaborate on in terms of this particular case, it is not a simple execution of a search warrant for physical evidence per se, like drugs or weapons that can be easily identified. So it's different. And so I think it's incumbent upon judges to understand when it comes to computer crimes, computer forensics, this paragraph is simply legally insufficient, in my opinion. Right. Let me hold this up real quick. This was an IP6 address as identified on page 4. Let me hold this number up and see if anybody can tell me what this number is. This is IP6 provides for approximately, can you see that?
Yeah, I see it. It's on page 4. And again, tomorrow I'm going to.
No. So read that.
Yeah.
What number is that?
I don't know.
Yeah,
that's how many unique IP6 addresses there are. You got that number?
Mm-hmm, yes.
All right. So as a defense attorney, I'm certainly going to be inquiring about that.
Put that up again. That I have you like on solo. Yeah. Now it's better seen. There we go. Yep.
Okay. Let me say this too. What is noticeably absent from this warrant are any weblog entries that they could have obtained prior to drafting and presenting this search warrant. What is a weblog entry? It's information provided in a log which includes the visitor's IP address, geographical location, the actions the visitor performs on the site, browser type, time on page, and on the site the visitor used before arriving to it. And logs should be stored on a separate computer. So in other words, law enforcement could have obtained usage of Rebekah Jones' devices that they believe they were going to seize prior to execution of this warrant. And that was not included. And I presume it wasn't included because if they did it, maybe they didn't see any nefarious activity relating to her former employer. Okay. And so that would have been exculpatory evidence tending to show this wasn't from her. And let me just touch upon the point that I haven't, that John and both Haiti, you have. Execution of this warrant, I understand the idea of exigent circumstances, that evidence could be lost or destroyed if they don't quickly act upon it. And we all come to think of, drugs being flushed down the toilet, right? In this case, it just seems, again, overly excessive to know the occupants of this house with no violent history, the who's home with children. And I know law enforcement's position is to come in with blazing guns and show of authority, but it really is disturbing when a family has to undergo this type of treatment for what is, if it is even a crime, as John said, to do this. And I'm sure that this directive was authorized by someone higher up. And it's just, it's unfortunate.
And Rob, let me just emphasize this point. If it was a warrant about drugs, guns, child pornography, the judge would have put right in there, kick in the door, go save the kidnapped child. There would have been different language. They knocked on the door. They waited for 20 minutes while she got dressed. She said goodbye to her kids. She set up the camera. She said goodbye to her kids a second time. She said she felt she was being arrested. She opened the door. She went outside. And then they came in with the guns. And that was uncalled for. They knew the judge didn't want them harassing these citizens, or the judge would have said, go break in the door. There's some terrible crime being committed. And again, I don't even think it's a crime. She denies she even sent it. But I don't think it's even a crime to try and get whistleblowers to blow the whistle in the news or tell a reporter that there's crimes being committed within the government, which there clearly was from her perspective.
Okay, two things. One, as a practice point, do we now considering everything we've been discussing during this hour, maybe advise telephonic transmission of information that is sensitive and not leave it memorialized in a text or email?
As lawyers?
Yeah, I mean, like if somebody wants to give a journalistic anonymous tip, shouldn't it be maybe over the phone instead of in writing?
No, what we should do is make sure that in America we're safe from governmental intrusion. If there's some people that lose their job, I think they'll have great civil suits against the state based upon the illegal search and seizure and the misleading of the judge. I for one, don't email or text much, but my staff all does. They communicate with all our clients by email, and they prefer it as opposed to being called all day long. So I don't think we can change how we practice based on this. This is just the government going rogue, and they should have never done it, and we shouldn't tolerate it. And
John, I know what we all wish the ideal to be, not to have government intruding and violating our privacy rights. I get it, but that's not likely going to ever happen. So as a practice point, we could disagree, John. I love you. We could disagree totally. I think it's safer to, if you're going to leave an anonymous tip or transmit an anonymous tip that you don't want it to come back and bite you in the backside, why not just transmit it over the phone where there's no written memorialization of what you're saying?
There was prosecutors in Miami that put recording devices in defense lawyers' offices and secretly recorded them meeting with their client. So the government will continue to try and overreach and bend the rules and break the rules until they're caught. and held accountable. Did anybody get arrested in that case? No, they just threw out the cases. But they were doing this routinely. So
I understand. I understand.
And so
Okay.
you just have to root.
Robert, if you want to touch on this point, you can. You don't have to. But as to your weblog mention, let me ask you this because I don't know. I'm asking to see if you may know the answer. The weblog is that something that stays and directly, conclusively confirms the correct IP? Like, in other words, what if they're spoofing or hacking? Do you know the answer to that? Where the weblog that's generated would be from the true IP address that is seeking to conceal itself.
Well, what it is, it's a review of what those computers were doing previously, and the sites it was searching, the emails it was sending. So you get a kind of a snapshot picture of what this person was up to prior to the alleged offense.
So is there a way that somebody that can hack in her system and then generate that weblog?
Probably.
Okay, well then the weblog may not be exculpatory and in fact additionally inculpatory, but still we have the issue of, did someone hack?
Well, I mean, there's no mention of it, so we have to presume there's no adverse history against her in her weblog.
I understand now the point that you're making. I get it. Okay, but at least for that one time it would generate. No, the one time that they're saying somebody.
Yeah, for the one time.
Okay. All right. Very well. Okay. So we're done with this broadcast. I hope everyone enjoyed it. We still have some viewers. Please share. This is a really helpful, informative material. Thank you, Robert, for coming on and offering up your time, which is incredibly valuable. You're much sought after attorney, as is John. Thank you also, John. I appreciate both of you. I love both of you very much. You guys at certain times act as mentors to me, are incredible friends. I want you, John, to please say, where can people contact you if they're seeking representation?
Oh, you just get on your IP address and I don't know. Google
Listen, what number can they call to get in contact? And give me a second so that I can put, what is your office line, McGuire? What is your office line so that they can call?
446-7659.
7659. So let me just repeat before I post this. John McGuire, 727-446-7659. Yes?
Yes, ma'am.
Okay, so let me put that on, and then I'm going to go to you, Robert. So if you want to reach Attorney John McGuire, he can be reached at 727-446-7659. Thanks, John, for participating in this broadcast this afternoon. And Robert, my great friend Robert, very good attorney. I met an incredible attorney, just a warrior, both John and him. Robert, where can the public, if they wish to contact you for legal representation, what is your office number? 727, I know that much.
Yep, 727-772-1941. Or just go on to Robert Eckard Law, and you can find me there.
Hold on a second. Okay, so if you want to reach out and seek a consultation with attorney, and I misspelled attorney, I'm sorry. I'm trying to wrap this up, but I gotta be on the road. Attorney Robert Eckard, 727-772-1941. Thanks, Rob, for joining me and John this afternoon. You can also just Google his name. He's in Clearwater, Robert Eckard. And John McGuire you're in Clearwater too, right, John? I believe so. Yes. Last time I went to your office, it was in Clearwater. Yes. Okay. Haiti Oropesa, I also practice law, criminal defense, some civil matters. You can reach me anytime for information, even including maybe some anonymous tips that you want to give on material you think that this outlet platform should address and have discussions, public discussions about. You can call me directly at 727-214-4930. Thanks for tuning in. Please share. Please follow the Florida You Judge Florida Facebook page so that you can receive upcoming notifications about really important topics, really interesting topics, so that you can be better informed as a citizen. Haiti Oropesa, happy holidays. This is the last broadcast for 2020. Stay safe, and I hope and wish you and your loved ones happy holidays. See you guys.
Merry Christmas. Thanks.
Bye-bye. Thank you.